I'm actually quite excited about this topic because having done lots and lots of disciplinary inquiries, it's as a lawyer, it's the most challenging and interesting side of practice because you get to act for a lot of nutcases. You get to act for some genuine psychopaths, or there's only one or two, a lot of sociopaths, a lot of people with an inability to communicate, a lot of people who have been caught in the middle of something completely unjustly, and then people who are completely innocent and fully acquitted. What I wanted to do over the next 20 minutes is I just want to give you a perspective of regulatory actions right through, give you an idea of the types of regulatory actions, an indication of where we're at and what the drivers are, because believe me, as a broker, I can assure you, your client becomes the subject of a regulatory action or a disciplinary action, right? It is the biggest event they're going to confront in their professional lives. For anyone, has anyone actually had a client go through this process, right? It's a major, major deal, right? And what I'm going to give to you today is a few, so to understand the background of it, understand the way it works, and give you some tips as to how to support your client through what will comfortably be the most difficult time of their professional life. So, obviously there's a focus on professional services, but I'm going to give you a much broader perspective. I'm going to talk about death, taxes and regulation. That's absolutely three certainties for a professional person. I'm going to take you through the types of regulation, who are the regulators, features of regulatory actions you must know, the policy response, how to help your clients, and I mean really to help them. And I have done hundreds and hundreds of these for a range of different professions over the last 23 years. ASIC prosecutions in the Federal Court, the Supreme Court, ACCC prosecutions, Medical Board, Dental Board, Physios Board, Psychologist Board. I've also prosecuted for the Chinese Medicine Registration Board, real estate agents, valuers, I mean the whole bit. And whilst there are differences between the professions, they've all got some similarities to them. But I do remember one particular dentist I acted for who thought it was an effective treatment to treat facial pain by inserting ozone through the anus. And that is a challenging concept, I know. The head is up here, just in case you'd be challenged physiologically. The head's here and the anus is a long way away. And
not in every case.
And the best defence I could come up with was, patient just got in the chair the wrong way. But but it's also managing the media as well. For a lot of the people in my team, we've done a lot of sexual misconduct cases as well. And you learn pretty well as to trying to get the other exits out of VCAT to get past the press because, the Herald Sun find out and they always want to get a photograph of your client. But for this particular dentist, I said to him, we're actually at an easy exit. There's only one or two ways out of VCAT. The journalists all know which way they are. For this particular client, we're actually at the old Medical Board in South Melbourne. This was back in the mid-90s. And I said to him, there is no reason for you to talk to the press. And he said, fine, David, I'll take your advice. So I left him there. And then lo and behold, I opened that was on a Friday, I opened the paper on Saturday morning, page 3 of The Age, is my client, smiling. And he sort of, in other circumstances, the smile was perfectly acceptable, except he had this tube in his hands, And the line might as well have said, look what I shove up asses. So anyway, that didn't go so well, and he was no longer a dentist after that particular case. All right, look, in my view, there are three types of regulation. There's general regulation of commerce by statute, right, which is the Trade Practices Act, Corporations Act, very broad-based, mediates conduct of all people. You are subject to it as well as insurance brokers. And there's professional regulation by statute, which is the dominant form of regulating professional life, and self-regulation by member association, right? Now, what are they? Let's just start with general regulation by statute. This is the regulation of general commercial activities as opposed to professional services. The main regulators, and certainly the best resourced, are ASIC, APRA, and the ACCC. Sorry, didn't pick up that typo. HCCC is the health regulator up in Queensland. They're the most dominant regulators. Occupational health and safety regulator in each state is obviously significant. And of course, there's the police who can prosecute for dishonest conduct. And most commonly, it's either dishonest conduct or sexual misconduct that dominates police activity at the moment. In relation to policy response, you're talking about statutory liability cover, and this is not PI, regulating general commercial activities. Just got to get that right? A PI policy is not going to cover these risks. Some might have been extended in the past, but people who've done that have been punished. In relation to standalone cover like this, you'll get defence costs and you'll get some fines and penalties covered. Will vary greatly depending on the policy. Management liability has picked up a lot of it, but as the experienced brokers in the room know, that's not a cure-all for everything. And you have significant issues about public policy around policy coverage. And this is really the idea that, and it's the concept of deterrence, which we'll talk about a bit later. Regulatory actions are not driven by general commercial principles, right? Regulatory actions are driven by regulating conduct, right? And there's two ways you regulate conduct. To summarise a huge body of law into two simple concepts. One is specific deterrence and the other one is general deterrence. The decision of the court has to specifically deter that person from doing the same thing again. And then also has to be general deterrence. The award or the penalty has to generally deter other people from doing the same thing again. Now, this is exactly the same as principles of sentencing in the criminal law, and it's fundamental to what drives regulators. So if your client comes to you and they're the subject of a regulatory action and they say, I'm just a scapegoat for all this, and start, complaining about how unjust it is, etc., they're absolutely right. They are a scapegoat, right? That's exactly the way general deterrence works, right? It makes an example. That's exactly what it's supposed to do, right? So and the reality is, for every person who gets caught by a regulator, there'll be another 10 or 20 who don't, right? That's just the way life is, right? There's no other way of catching everybody. And if your client starts saying to the regulator, just leave me alone, why don't you go and try and find some real crooks, they're not going to listen very long at all, right? So that's the sick. Now, when you're talking about deterrence, how it intersects with insurance, and there's a lot written about this. We've done it in previous ProRisk papers, and certainly my colleague Jane Coventry and I have written fairly extensively on the topic. It's this idea of how much you can insure, right? And this is all about how much the courts, and our legislators to an extent, are going to let you insure risk for fines and penalties. And the argument is that if you can insure against a fine, then where's the general deterrence, right? So if you can do this conduct and then just grab on an insurance policy and just go on your merry way because your insurer's going to look after the fine, well, where is the deterrent effect? And Gary's going to talk a lot more about that in the context of awarding costs of regulatory actions as well. Now, these are common types of general regulatory actions. An ASIC by ASIC, banning company directors, usually seeking a fine and a banning order. Recently, Bill Lusky was banned for life and a $350,000 fine in relation to the Prime Trust collapse. The non-executive directors had fines, $50,000 to $75,000 and banning orders of 3 to 5 years. They've all gone on appeal to the full court. Court action by the ACCC seeking fines and injunctions. In the age of Google, you can find these out very quickly. They're all on the ACCC website, all the pending, current and past. So you can see the kind of conduct that's regulated and the kind of fines that are handed out. Occupational health and safety prosecutions, again, freely available on the website of any of the regulators, WorkSafe in Victoria. And then ASIC action against financial advisors or auditors seeking banning orders from engaging in licensed activity. Probably the more recent one was the auditor of Banksia, who agreed to a 5-year ban. Now, so that's general commerce. In relation to professional regulation by statute, this is a mix. All right, it's a bit of an odd mixed bag of legislation and self-regulation. In the health sector, you've got a national legislative scheme. All right, so it's now the Australian Health Practitioners Registration Agency handles registration on a national basis. This is really unique to Australia. I don't think any other country in the world's actually got it, although the UK has got something very similar. Now, APRA handles prosecutions only along the southern seaboard, Western Australia, South Australia and Victoria. The HCCC in New South Wales handles prosecutions up there, and the HQCC in Queensland, entirely political reasons. I don't understand why New South Wales and Queensland jumped out, but New South Wales always does. As I say to my colleagues in Sydney, why do you do that? And they go, sheep follow, Dave, sheep follow. They'll always stand out on their own. I don't like Sydney-siders. Finance and construction professions aren't so uniform. Lawyers, estate agents, stockbrokers, financial advisors, insurance brokers and mortgage brokers need to be licensed. Mortgage brokers the most recent to a licensing regime. valuers and accountants are largely self-regulated. Always surprised me that accountants are self-regulated, but the three large registers, which I deal with in the paper, the three large associations like the NIA and the CPA self-regulate, and we actually got very sophisticated disciplinary systems, which I'll go to in a moment. Common types of regulatory actions involving professionals. Well, in a health professional, the ones that go the distance are almost always involving sexual misconduct. If you look at the decisions in VCAT or any other tribunal around the country, that pretty much dominates the regulatory landscape. Then there's often quite a few actions to cancel the licence of a finance professional, usually for dishonesty. That's something that will get the attention of the regulator. There's quite a lot of building practitioners board actions against builders and construction professionals for shoddy workmanship, and you often have these regulatory actions running in tandem to civil cases. So this is the other thing your clients have got to know. A regulatory action can start, a civil action is often going to be off the back of it, and then their member association will probably try and cancel them as well. Right? So you often get three things running in tandem, and that's that. And for your clients, that extra thing going, my God, who else is after me now? Like it really is an unpleasant place to be. All right, and now finally, self-regulation by member association. Yeah, usually the most fun and interesting for the lawyers. Very simple concept. You're a member of a club, you're bound by the club rules, right? Golf clubs, professional associations, the AFL, the NRL, they're just clubs, right? Not really subject to a licensing regime or any real statute. And the club rules control when membership or certification can be cancelled, suspended or not renewed, for example, the AFL. Now, the disciplinary process is governed by the constitution of the organisation. Some organisations handle this well and others are just awful. For instance, the AFL, the CPAs, extremely sophisticated systems, but if you get into other members associations like the Junior Baseball Association, that can often have terrible fights between members, and in one case we acted for the Australian Scrabble Association. I had a ding-dong battle about someone allegedly keeping a Z and an X, on the, under the table and putting it out, and made the mistake apparently of putting an X out on the table when there was already an X out there. So that all went to the court, ended up on Channel 9, as you'd expect, and didn't have a policy that responded, but I understand there's a non-profit policy coming into the market that probably will. The only real legal obligation on member clubs is that there's an overriding legal obligation to an accordant accused with natural justice, right? And this, again, a lot of law, very simple concept. Clearly state the allegations, give them time to respond. But really, for people who don't have legal training in a lot of these member associations, you'd be amazed how they just stuff that up. But I've put down the bottom there that intervention by courts is rare, often sensational, and usually ineffective. The only remedy for a breach of natural justice is really to get the thing heard again, right? So you say you didn't state the allegations clearly, you didn't give me enough time. You go up to court, court agrees with them, say no, breach natural justice. You get the privilege of going through this all again. And all that really happens is that the club works out to do it properly and then stitches you up right the second time, right? So that's why it's usually ineffective. Now, to give you an example of self-regulation, you probably can't see it from where you are, but this is the web page from the CPA. They go through member conduct and discipline. If you want to see how effective self-regulation works, and a lot of you would have written PI policies that provide defence cost cover for exactly this process. I've been through it quite a few times. They really do it quite effectively. Give you a notice, you appear before a panel of 4. It's people who are experienced and know what they're doing, and the penalties, for the most part, aren't that great, but certainly have the effect of regulating members, because members don't want to appear there. But then you get to, can anyone remember what happened here to Diesel Williams back in 1997? Lee, how long was he suspended for?
9 weeks.
9 weeks. Can you name the umpire? It was Greg Coates, I think, was the Andrew Coates, sorry, as it says there, but he pushed Andrew Coates. He was suspended for 9 weeks. This was after round 1. He, at the time, was the highest paid player who'd just gone to Carlton. Carlton at those days thought they were untouchable, and appealed, and Justice Hedigan granted an injunction, but then at round 9, when it was finally heard, granted a permanent injunction saying that the AFL should have appeal processes, and that got overturned in the overturned in the Court of Appeal, and Diesel Williams still served his 9-match ban. And then, of course, there's people who take on the system in the courts, and ultimately it just doesn't work. And then you have self-regulation. Now, one feature of self-regulation is that you're usually judged by your own. Now, this was the dominant form of professional regulation before 1994, when VCAT effectively became the forum, which is effectively judicial controlled in a way. There's a lower level of regulation under that called a PPSP, which is a professional person standards panel hearing, which is usually doesn't have lawyers on it, and you are judged by your own. Generally professional people find being judged by their own as a lot more difficult than being judged by the courts, right? So this is actually why, didn't mean to get so fundamental about our judicial system with you, but this is why judges wear wigs. It's why you go into courts and there's very high ceilings and what might seem to be unfriendly and imposing circumstances. It's all about serving a greater purpose, right? It's all about there being independence, impartiality, and justice being blind, right? That you're not actually being judged by someone you know, as opposed to you guys, if you happen to have a disciplinary hearing before RIBNA, which I've heard doesn't happen very often, but Gary Gribbin's the man who would be judging you, and can you just imagine? You sit there on the other table and there's Gribbo looking at you going, you are stuffed, mate.
Good-looking rooster.
before it even happens. All right, so moving on. The paper you've got on your table gives you a summary. This is more to just show you that it's there. It's a useful resource, showing you which regulator responds for which particular profession. Accountants, self-regulation, valuer is combination, as I referred to in the paper, but mainly membership of the API is the determinant of your professional livelihood. Mortgage brokers, ASIC, insurance brokers, ASIC and APRA, financial advisors, usually ASIC, stockbroker, ASIC, real estate agents, the Small Business Commissioner, and then for lawyers, the Legal Services Board. That gives you a summary of construction and construction professionals. I won't go through that, but then you can see health is really quite uniform. These are the 12 main professions. There's another profession called Aboriginal and Torres Strait Islander practitioners, of which I think there's 42 registrants that I haven't included there. But the regulator in each case is the national board that's represented by APRA. And the relevant policy is PI, but sublimited defence cost cover. And then general commerce, it's pretty simple. Company directors subject to the Corps Act and prosecutions by ASIC. Entity risk, various, but the Australian Consumer Law, otherwise called the Competition and Consumer Act 2010 Corporations Act. And in this case, you've got D&O and management liability being the policy response. Now, I've already dealt with in regulatory actions, it's not really about the money. The other feature of this is that defence costs are much, much higher than the penalties. This is an unusual feature of it. For example, prosecution of directors, you will comfortably spend $5 million in defence costs and arguing about penalties of 50 or 70 grand, right? Or a banning order of 3 to 5 years. And that's because this is not about the money, right? This is all about regulation and reputation, right? Your clients might get a banning order of 3 to 5 years and what would seem to be a relatively inconsequential fine, but their professional life is pretty much over if it goes badly. Some people, rise like the ashes, but in the age of Google now, you've got to be pretty lucky that the first thing that doesn't come up when you Google that person's name is the latest regulatory action. And I've had consultants trying to work out how you bump someone on the second page of a Google search. The regulators are onto that. It's a bit harder to do than you might have thought. So it's all about defending reputations, and it's in this sector that you start to understand that reputations, whilst not priceless, are bloody expensive. Because it's not just about the money and the livelihood, it's what defines a person. So if you're a doctor and you get threatened that you can't be a doctor anymore, that's fine. You've done 20 years as an insurance broker and all of a sudden someone's telling you you can't be an insurance broker anymore, it's bad, right? Lawyer, just psychologically, it's very, very damaging. And frankly, there's a very high risk of suicide, both in terms of the people you're representing and complainants as well. And any lawyers that practice in this field has had that experience. They've done a lot of it. Now, Gary will talk about will ASIC recover costs, but let's just be clear about this. If costs are going to be awarded on an indemnity basis, the amount you're going to be paying in costs makes the fines completely inconsequential. I mean, why argue about whether the fine should be 50 or 100 grand if you're just going to get hit with a truck of $5 million? at the end of it, and will the policies be able to respond to the costs? And Gary's going to talk about that a bit later. And it's a mixed approach in relation to cost recovery. Some regulators do, some don't. Health practitioners up in Queensland get cost orders all the time. Lawyers around the country get cost orders in regulatory actions, but generally otherwise costs aren't recovered by the regulator. Now, get on to just the last couple of minutes. Our first thing is regulatory actions start with a request for information. Right? It's very rare that you just end up, right, and people will be asked to be going to an interview or to produce documents. Now, it's at this point the insurer just has to be notified, right? Now, the regulators will often say it's got to be kept confidential, right? But you as brokers don't get distracted by that, right? The regulator is not going to complain about you notifying the insurer, right? And it's critical at that point that the insurer be notified, get involved, and you actually get lawyers who know what they're doing. Now, there's plenty of them in this field. Obviously, this firm's one of them, but there are plenty of others. But believe me, the difference between someone who actually knows what they're doing at this point in time and someone who doesn't is vast. And I talk about this quite a bit in a paper, but the first steps you take in a regulatory action are vital. Do you cooperate or do you shut up shop? In South Australia, if you're getting a WorkSafe investigation, everyone just shuts up shop, right? That's just standard in the market. No one talks to the regulator. That's that, right? So advice in that jurisdiction, it's different in Victoria. You wouldn't necessarily do that. It will depend on a lot of factors about the size of your client, the breadth of their reach, their relationship with the regulator, and the circumstances of the case. It's a very stressful event, and particularly for professional people. But here are some really common mistakes, right? When your client writes back, this happens a lot in the professional sector, ill-considered "how dare you" responses. Like, I haven't done anything wrong. How dare you? I'm going to take you up to the High Court. I'm going to bankrupt you as a regulator. Like, if you want one way to get yourself to the top of the regulatory pile so that they totally make a mess of you, then just do that. And often the responses will have inaccuracies or things that might seem accurate at the time, but on closer examination just aren't. And it's at this time your clients will start to understand that there is a difference between the way we interact with each other and then the legal standard. Like, the legal standard is what really, really happened at that time in minute detail, right? And no one, even the best lawyer in the land, is not prepared for that unless they actually do some preparation. Telling the regulator to go and find some real crooks, love that one. Treating the regulator as your friend, hoping they'll go away and sing like a canary as a result. They won't. They'll take whatever you give them and they'll use it against you, right? That's their job. And the amount of people I've seen hung on what they've said at the initial interview, and when something is really in the balance, it's really pretty tragic. Providing lots of information without really checking it through, and worst of all, incurring significant defence costs without notifying. So not only does your client have the pressure of a regulatory action, they've now got to fight with their insurer as well. The policy response, usually defence costs, but civil liability and representation costs are still treated differently in those policies. Don't assume a liability policy provides the coverage, and certainly don't assume that the fines and penalties are covered. So just to give my 5 key points before handing over to Gary. Regulatory landscape is complex, but hopefully this paper will just make you understand the different types, and so that you can understand that each of them will require a different response. But you really do need to get someone involved who knows what they're doing, and experience with that particular regulator goes a long, long way. Second point is defence costs for regulatory actions is not a given. You've got to make sure that the policy covers it. It will be covered separately. A civil claim for damages, it is not. Fines and penalties is not covered in PI. There's limited cover in the ML and D&O policies, and regulations are very stressful for your client. Notify early and get them on something experienced. You get a client through this, you should have a client for life. And costs recovered by ASIC is a significant issue for the future, to which my esteemed colleague Gary Gribbin is going to deal with in more detail.
I want to start with the Australian consumer law. In particular, inroads being made into unfair contract provisions. I'll read this because it's important. A term in a contract may be declared void if deemed unfair on the basis that it causes a significant imbalance in the parties' rights and obligations under the contract, if it was not reasonably necessary to the legitimate interests of the party advantaged, and it would cause detriment to a consumer were it to be relied upon. So the unfair contracts provisions as currently writ apply only to individuals. In that regard, they have a significance for you as advisors to people practising as professionals. The spectre, however, and it seems to me to be a certainty eventually, is that the realm of the Unfair Contract Act provisions will be extended to small business. And we currently have a raft of issues with how small business is defined, because small business isn't always so terribly small. Now, the implication for you as advisors is simple enough. It relates to that problematic, vexatious area of indemnity and hold harmless provisions in professional services contracts. As brokers, you're driven crazy, I'm sure, by clients coming to you persistently and consistently seeking advice about the implications of the contractual terms being presented to them. Anyone who advises a client providing any form of professional advice or service in respect of the mining industry is painfully aware of the bargaining power imbalance that exists between huge mining entities and their service providers. They seem to make the contractor responsible for everything this side of global thermonuclear war. Hold harmless provisions in leases, contracts with governments at all levels, whether it be federal, state or local. In each of those areas, there are inevitably those indemnity and hold harmless contractual provisions. Now, where an individual is contracting on that basis, it seems to me to be axiomatic that a significant imbalance will exist and that the unfair contract provisions will apply. For them, it doesn't free the spectre of becoming responsible for actions that fall well outside their control, reasonably or otherwise. For companies transferring liability, if you're advising large corporates and your advice has been to employ such indemnity and hold harmless provisions, then you may have to rethink about the effectiveness of them. As these provisions become pertinent to a much larger raft of clients in the small business area, then clearly the whole future of indemnity and hold harmless provisions and the advice you provide is going to have to be very carefully re-examined. David has provided an excellent segue for me in respect of ASIC and the possibility of ASIC pursuing very widespread cost recoveries. Where ASIC mounts a successful prosecution, and those, given recent history, are rare in their nature, ASIC has a rather poor record of choosing targets and of successfully prosecuting. They have a huge burgeoning expense in respect of prosecutions, as well as in respect of the bureaucratic portmanteau that they've become. So ASIC is now going to recover its costs in the same way that APRA does. So that from next year, as insurance brokers, you will now become responsible for funding a portion of ASIC's operating costs, not its prosecution costs. The levy is likely to be something of the order of $7,500. If you're a product issuer, it may well be that it's up to $31,000. So you'll need to consider the number of Australian financial services licences you have within the business, because it will be on a licensee basis that ASIC levies that. That's one issue, and it's not terribly momentous in its nature. Far more significant for you is the possibility, and for your clients, is the possibility of ASIC launching recovery actions under Section 91 of their Act for all the costs incurred in the investigation and litigation of successful actions. Because as David has said, there are actions involving relatively small fines, $20,000 to $50,000, which in an investigative and prosecutorial expense sense are generating costs of $3, $4 and $5 million. The reality is that those costs are not contemporarily recoverable under any policy. So you will need to watch that position very, very carefully indeed. Management liability policies may provide some coverage. It's uncertain at this stage. You may be looking at an environment in which the insurers amend the management liability coverage, more than likely to expressly exclude such costs, because they are going to be very significant. But clearly, if this happens, the days of any ASIC-regulated entity being able to buy $1 million of management liability cover will be well past. You'll be looking at an absolute minimum of $5 million. For them, not terribly good news. For you as brokers, not necessarily poor. It just means you sell a little bit more. Poole and Chubb in 2014 was a very interesting case at a number of levels. It was, of course, widely covered in the media through the deliberations and decisions of ICAC. Poole was a director of the Doyles Creek Mining Company. It was granted a licence in 2008 without going to competitive tender as required under the Act in New South Wales. This was visited upon them by the Minister. It was a union deal, supposedly an educational facility, you may recall. An ICAC investigation in 2013 involved Poole in costs of over $650,000, just Poole's costs, for which he sought indemnity under the relevant directors and officers liability policy. Chubb, as the insurer, denied, asserting a breach of Section 21, a failure on the part of Poole to disclose to them the knowledge that he had. The Chubb contention was that Poole ought properly to have known the manner in which the lease was obtained, and therefore to have been warned effectively that an inquiry was at some stage likely to occur. In 2009, he should have been aware that there was an emerging controversy and that there might be an ICAC investigation, far more likely than not. That wasn't disclosed on the proposal completed in 2009. The decision was simple enough. Chubb failed in its action. The court held that Chubb had failed to prove that fraudulent non-disclosure or misrepresentation had occurred. Chubb called no witnesses to prove the allegations of fraud. It simply relied on the insinuation arising out of the examination and cross-examination of Mr. Poole, and the inferences from that evidence upon which it drew conclusions. This is another example. In all areas, an allegation of fraud is a very, very serious matter indeed. Not only is it a criminal action, but you are impugning completely the honesty and integrity of the person involved. Courts demand, quite properly so, that any such allegations be proved to a very high point of confidence. Sienkiewicz, not easy always to say, particularly after lunch for Macca, and the Salisbury Group in 2015. Claims were made against two financial advisors and their AFSL holder, alleging advice given was inappropriate to the risk profile and needs of the clients concerned. A common enough allegation against financial advisors. The PI insurer declined indemnity on the basis that the insuring clause limited cover to losses flowing from a claim, alleged act or error in the performance of the professional services. Relevantly defined to mean financial planning encompassing advice of approved investment products. The difficulty for the insurer here was that the term was not defined. Approved investment products was not anywhere in the policy clearly defined. Insurers believe it to be a well understood term, meaning the approved product list. Any broker handling, as a matter of routine, the professional indemnity affairs of financial planners and advisors would also, I'd suggest, understand it to mean the approved product list. I've not seen a PI policy over the last decade in respect of that segment that hasn't been so curtailed. There is always reference of the approved product list, just as there is for you and your PI cover as insurance brokers. The plaintiff sought to argue that encompassing was not a limiting word, that financial planning was broader than providing advice on financial products, and that approved was not limited to products on the approved product list. Fortunately for the industry, the court applied a very common sense view here. The language of the policy wasn't tortured. It wasn't in its nature inherently ambiguous, unclear, not certain. Courts in interpreting contracts will give to the wordings a reasonable interpretation. They will not unduly strain or stretch the English language and will certainly not apply the rule of contra proferentum unless there is clearly an ambiguity. Travellers Property and Casualty and Federal Recovery Services, a recent case in the US. Notable not because it provided any new law, but because it's one of the few cases that I've seen regarding cyber liability, which has become such an important feature of the landscape contemporarily. We're all out there looking at cyber liability, advising clients about cyber liability. But I have to pause and wonder whether the industry, both on the underwriting side and the broking side, really understands what is covered in respect of cyber liability. So as this is one of the few litigated cases that has run to decision, I think it's worthwhile having a quick look at it. Global Fitness was acquired by an LA company. They outsourced all their financial management, records management, including credit card details, to Federal Recovery Services. As part of the vendor contract, the deal was that Federal Recovery Services would make available to LA Fitness, the acquiring entity, all the customer records, including the credit card details. Federal Recovery Services declined to make them available. So Global, being the only party privy to the contract, initiated action against Federal Recovery Services. Federal lodged a claim under its cyber liability policy, seeking indemnity for the defence costs associated with that action launched by Global, its client, against it. Should it be covered? Well, of course not. The court held that the Travellers' policy did not respond and the insurer had no duty to defend the proceedings. The court quite properly determined that the policy covered only errors and omissions and negligent acts. This was a deliberate, considered, purposeful business decision on the part of Federal Recovery Services, one of those instances where you wonder, oh my God, what got into their mind? After all, what is the last thing that goes through a fly's mind when it hits a windscreen at 70 miles an hour? Exactly. The court act here that the wrongful act was not a negligent act and that the policy did not respond. The FBI annual report on cyber indicated that business email compromises and fraud was the #1 issue. Intimidation and extortion scams. Several brokers I know have been locked out of their systems and have been forced in the end to pay ransoms. In both cases, they paid $10,000 to regain access to their systems. One wonders how long it will be before the next lot happens. Government impersonation scams. Well, I think the government is constantly impersonating, isn't it? I'm from the government, I'm here to help you. If that's not impersonation, I'm not sure what is. Confidence fraud and romance scam. Well, together with my dear friend Leggatt, I've fallen victim to a great many of those romance scams. But we're lovers, after all. Real estate fraud. Any numbers of frauds have been perpetrated, property has been sold, leases entered for property that simply doesn't exist. Similarly in the United States, auto sales. So cyber fraud, a really emerging, desperately important area of advice for clients, but make sure that your client understands what they're getting. Make sure as professionals that you're on top of what is being provided by the policy and by the inherent limitations of cover. Matton Developments and CGU, my favourite area, I think, of insurance law remains good faith, utmost good faith, and its implications for insurers, policyholders, and in pleadings. Matton sought indemnity in relation to damage to a crane caused by its collapse. The insurer was not aware of financing obligations of Matton. No interested party was noted on the policy in respect of the policy of insurance on the crane. CGU reserved its position whilst it undertook forensic examination of the circumstances regarding the damage which was consequent upon a significant collapse. It later relied upon the forensic evidence that it had gathered to deny the claim. It denied the claim on the basis that the collapse was not an accident, that it was quite reckless behaviour. The insured sought to enforce cover. It failed to do that. And it sought to obtain damages for breach of Section 13, that is, a breach of the requirement that the parties exercise between themselves in all their dealings the utmost good faith. The pleading was novel. It was based on the premise at law that breach of a statutory duty is in fact a tort, which therefore exposes the party, the tortfeasor, to damages. Justice Flanagan, in a most interesting decision, greatly flawed in a lot of respects, it's been suggested, but correct in terms of its outcome, held that Section 13 did not impose a privately actionable statutory duty, so the insured was limited to contractual damages only. No tort of bad faith exists in Australia as it does in the United States. The raft of extra contractual obligations to which liability and property insurers, but particularly liability insurers in the United States, are exposed is legion. Not in all states, but in the majority. Here we have no such tort, so a breach of the duty of utmost good faith does not allow an action to proceed in bad faith. No such tort exists here. In a great many respects, it would be a far more interesting and enlivened market if it did. Finally today, O'Farrell and Allianz in 2015. O'Farrell insured his car with Allianz. The car was stolen. He lodged a claim which was denied by the insurer. Allianz denied on the basis that he'd failed to disclose criminal convictions arising out of minor brawls in a pub. Well, if criminal convictions for minor brawls in a pub disqualified you from insurance, half this room would probably not ever get insurance. O'Farrell submitted he was only asked for convictions related to driving. He was not, he alleged, advised about the requirement in respect of disclosure, nor provided with the warning regarding a failure to observe the duty and the consequences. New South Wales Court of Appeal considered the matter after the District Court had sided with Allianz, had found in favour of Allianz. Now, the District Court in New South Wales is the font of all poor law in Australia and poor applications of the law. As David said, he doesn't like Sydney-siders, he doesn't like New South Wales. I think the people are okay, but the District Court is a cesspit. The decision here, a unanimous decision in the Court of Appeal, was that Section 21A, relating to retail product, requires specific questions to be put to insureds. The days of having very general questions is long past. As insurance brokers, as professionals advising clients, and all of you tend to get involved in the personal lines area because you're supporting corporate business, you should, I hope, be well aware of this. So specific questions are required to be put. If an item of information is important in the consideration by underwriters, then it behoves them to obtain that specific piece of information, not to be waiting for it to be volunteered, as happened in the good old, bad old days. Section 22 was also directly relevant here, the requirement that the insured be warned before the contract is entered into of the requirements relating to the duty of disclosure and of the consequences of a failure to disclose. It was asserted here in evidence by the insured that he rang asking for insurance, was given a quote. After he was given a quote, he was asked questions about driving. He was then subsequently issued, having confirmed that he wanted the cover, with an invoice which raised the duty in the normal way that brokers' invoices do, and a policy schedule which also mentioned the Section 22 requirements. In the opinion of the court, that was not enough. It needed to be stronger. So in this case, I don't know whether Allianz pursued the broker, but the allegation was that the broker, upon whom the duty falls, where a broker is involved, had not properly alerted the client to Section 22 and to the duty of disclosure. Make sure that you don't make that trap. Amendments are coming effective on the 28th of December 2015, which will result in a change in disclosure in relation to retail products. There will be a disclosure regime in respect of new business and an amended disclosure regime in respect of the renewal of retail products. You will need to make sure that you are aware of those and that those requirements are emphatically embedded in your business processes in the offices in which you work.